I'm Jeff Liebenson of Liebenson Law in New York, and I'm president of the International Association of Entertainment Lawyers, which is very proud to host this panel discussion on multi-platform licensing. The IAEL has 400 lawyers around the world, and several of our members are on the panel today. As multi-platform activities become more prevalent and more global in nature, the IAEL has a key role to play as it brings together legal expertise from around the world, and each market, of course, has different laws, different market forces, different deal structures. The multi-platform environment is quickly changing. As new media and devices develop and overlap, lines blur, and new opportunities arise. How can these opportunities be maximized without cannibalizing each other? How can existing revenue streams be protected while simultaneously developing new ones? And how does one structure deals in this very fast-changing environment? To negotiate among the different platforms and devices, the deal maker needs to stay up to the minute on what they are, how they operate, how they differ, and how they may conflict. Without that knowledge, it's impossible to establish effective windows that do not conflict or define how revenues are to be calculated from different revenue sources. Contractual definitions can be crucial to distinguish between platforms and to define the scope of rights. What do television rights mean? What do online and mobile rights mean in an environment in which primetime programming can be accessed from a website and viewed over a mobile phone or a tablet? Time Warner's recent launch of an app enabling its customers to access not only particular programs but entire channels gave rise to it being targeted with cease and desist letters from various program networks. Now, this has been a big item in the news for the last several days. Were iPad apps known when Time Warner negotiated its carriage agreements? Regardless, what is the scope of rights in those contracts? And what's coming next to challenge our current understanding? To answer all of this and more, we have assembled a stellar panel ranging from technologists to attorneys, from the United States to Europe to China. First, we have Peter Bradley of Gracenote, a technology and digital infrastructure company that has been active in enabling and enriching digital exploitation. The rest of our panelists are all experienced entertainment lawyers who each brings his own or her own unique perspective to this issue. We have John McLellan from Haldanes in Hong Kong, Louise Nums from Los Angeles, Jonathan Blair from Simkins in London, Massimo Travostino from Studio Legale, Pecoraro-Travostino in Torino, Italy, and Tom Guida from Loeb in New York. We're going to start with presentations from the panelists, and we're going to leave time for questions from all of you. So, Peter, why don't you start us off?
Hello. As you've been told, I'm the only non-attorney sitting up here. I feel a little bit like Charlie Sheen looking at his contract with Warner Brothers here, so I'm a little intimidated. But I'm going to give you a quick understanding of what we do. I think this is the clicker. Oh, okay, there it is. So what Gracenote does is it actually is a company that licenses, distributes, and manages metadata, the information around a piece of content. And we build applications around the basis of that database to be utilized by other companies. So what I'm going to show you right here, since we're on the topic of third screens, is two examples of a third screen experience. The first example is a wireframe. It really shows you how our product listens to a television program. By listening to it, it can identify the program, and then you can link in and start exploring more information. So in this case, it's Iron Man. You can read about Charlie Sheen. You can look at his videography and see what other films he's been in. And by doing that, you can also eventually click into a video and see a preview, as well as ultimately engage in commerce. So this gives you a basic understanding of how our metadata powers this experience. And a real life experience is this one, which we did for ABC. It's Grey's Anatomy. So once again, our technology and metadata and our linking database is powering this experience. So it's listening to the show. As the show is playing, the screen on the iPad changes. When an actor enters a scene or leaves a scene, as well as it's giving you additional monetization information and opportunities. It's identifying the background songs that are being played and bringing up the album artwork, as well as it's allowing people to engage in trivia and questionnaires and all kinds of little things to give the user a more immersive experience. So here you're seeing the ability to tweet and add Facebook, all within this experience, keeping in mind that all the background information is changing as the scenes in the program change as well. And that's it. That's pretty much who we are, and that should give you an understanding of how we utilize data and content to power other devices.
John McLellan, I'm a lawyer based in Hong Kong, but we service a wide range of clients both in Asia and from North America and Europe looking to license content into the region. I don't know how many of you have been to Asia, but it's got a relatively young, fast, and technologically advanced communications platform with a number of operators who service an increasingly affluent, early adopter, young population. So there's a real opportunity to consume content through a variety of new platforms, devices. So the challenges are very real. Obviously, you're dealing with copyright work, whether it's the form of music or audiovisual works or television signals. And so the starting point in terms of licensing that is an agreement between the content owner or controller and the operator. And the guts of that is obviously the scope of the grant of rights. And we as lawyers spend a good deal of our time when we're drafting these deals. And you've all seen them at the very beginning of the agreement or the very end of the agreement. You'll have reams and reams of definitions. And unless you're a lawyer or a business affairs executive, you probably just skip all that and go straight to how much you're going to pay or how much you're going to get. But this is the crux of the issue, as Jeff suggested, is what is television, what is a mobile device, and very often we spend our time actually mining far deeper than that into looking at what are the operating systems that are being utilized by the operator, what functionality does it have, and I think that certainly in Asia, licensing in content, I think you have to understand very clearly the functionality and the offerings of your potential licensee and work through very carefully what you are and are not prepared to license in terms of a scope of rights, paying very, very careful attention to the form of definitions. The other point I think, again, from an Asian perspective, is that it is not a homogeneous market. It is not North America, it's not Europe, it's a collection of large countries with very different cultural, religious, and regulatory frameworks. And so, again, when you're licensing in, think carefully as to how much you're prepared to spend or how much control you're prepared to give up in terms of repurposing your content, because there will be issues in terms of whether it's obviously sexual content, or in some countries homosexuality is still outlawed. So you'll have to give careful thought in terms of licensing to these very specific issues.
Hello, I'm Louise Nemschoff from Nemschoff Law Offices in Los Angeles, California. I represent parties from outside the United States doing business in the United States, parties doing business within the United States, and parties representing parties in the US doing business abroad. These days, I probably spend 40% of my time just negotiating definitions in various kinds of distribution contracts. The other 40% I probably spend negotiating windows. And when I started in this business back in the dark ages when floppy disks were 5 1/4 inches and actually floppy, these were almost never negotiated. The first thing to remember about definitions is that it depends on the context in which you're negotiating. So one sort of definitions may be appropriate if you are licensing a product to a particular territory or internationally on a language by language basis. If you're worldwide Spanish language, and you're relying on your licensee to basically take care of how it's going to be exploited. It's different when you're trying to exploit licenses within a territory or exploit rights within a territory. You need to focus on, what's the difference between the internet? What's the difference between wireless? How are they overlapping? Is there a difference between video rental and video streaming? There are also going to be differences in terms of whether or not you're licensing music, episodic television, or feature films. If you're selling things in the drama genre, or game shows, or things that incorporate music. At one point we were all defining rights based on the device that was used. Originally it was like, if it's television, it's going to your television, and is it going over the air, is it going via cable, or is it going by satellite? And then the computer came along, and there were efforts to tie it to, well, does it go to a computer? And then there were mobile devices. Well, now these devices all have so many similar functions. A telephone is a computer. A telephone can access the public internet. It can also access private subscription services like those offered by Verizon or those offered by cable companies. And so we're also looking at things like at defining rights based on economic models. For example, is it a single-use type of exploitation, more along the pay-per-view model? Perhaps doesn't matter how it's transmitted. Is it a permanent use, sometimes called download to own? I would note, quite interestingly, within the past year, I've been negotiating a download to own definition with a major independent label. And their starting point of the definition was download to own means someone can make a copy to a DVD. And so we've been arguing for months and months, well, shouldn't this include downloads to a hard drive, downloads to flash drives, downloads to other media? And of course, it's still unresolved, and now we're going to have to bring in, well, can someone essentially download to the cloud? I mean, can you maintain your copy in the cloud in either a secure locker or some other sort of fashion? A couple of other things I want to mention. Don't forget about this whole range of other rights beyond the sort of traditional online digital rights. Don't forget about live performance rights. The Glee transmedia franchise, a big key component of that is live touring. And if you've got music or dance, this is going to be a critical component. You need to decide in advance who's going to own it, who's going to control it, and how those revenues are going to be shared. And also game rights. These run a wide range. Are you talking console games? And if so, which platforms? Are you talking casual games for PC, for social networks? Are you talking what's called gamification, which is basically using branded entertainment to create games and attract interest to particular product? Are these games that are going to be played along at the same time as programs are being broadcast or otherwise delivered, or are they going to be sort of a standalone element? Also, I want to mention merchandising, because one of the things that we are coming to is, you know, the day when you can click on what the outfit that Holly Robinson Peete is wearing on The View and purchase it, and how are those revenues going to be divided up? And then lastly, as mentioned before, the data, who owns it, who pays for it, who gets to use it, and sort of my bottom rule, there are just two things. Probably the most important clause in any contract is the reservation of rights clause. All rights not expressly granted are hereby reserved to licensor, and that's from the licensor's perspective. Obviously, the licensee wants to get as many as they can. If you're licensing content, the more rights you can actually exploit in a meaningful way before you have to license it to a major player, the more likely you are going to be able to hold on to those rights. And finally, the definitions, like everything else, are going to be tied to the bargaining power of the parties. That's a very quick thumbnail overview of a huge issue. I'll now pass this along to Jonathan.
Thank you. My name is Jonathan Blair. I am a partner in a law firm in London called Simkins, specializing in film and TV. And just in a few words about apps. As you know, apps are essentially computer software allowing the user to be able to interact for single or multiple use. The apps business has grown exponentially since the impact of Apple in 2007 and the development of iTunes. The business is predominantly dominated by Apple, which last year's revenues were about $1.8 billion and a market worth about $2.3 billion. And this year, the projections are up to $4 billion. So it's a huge business and a huge opportunity for rights owners. But there are a series of legal pitfalls available before embarking on an apps application. In London, if you're a rights holder, the biggest challenge is to find the appropriate development partner, because they are so highly in demand. Once you manage to be able to commission someone that's got the ability to be able to produce an app, then it's important, obviously, to concentrate on your development agreement. The initial starting point is the copyright in the software. You'll be lucky if you actually manage to get an assignment of the copyright in the software. Normally, you'll get a non-exclusive license of the source code from the developer. But if you do manage to obtain the copyright, then in certain jurisdictions you can register that copyright, certainly in the US and I think also in France. The next, if you're actually developing the software in-house, then clearly you have to make sure that the people that are working for you are under work-for-hire agreements and have the suitable assignment of copyright, and also prevented from restricted in terms of competition. So you may wish to introduce restricted covenants in your employment agreement that they cannot work on similar products, for a period of time after they leave the company. In terms of the development of the software, you have to introduce milestones. So it's important that the developer actually manages to deliver on time, and if he doesn't deliver on time, then there are kind of liquidated damages provisions which allow you to claw back some of your development budget. The other main concerns relate to technical support and know-how. It may be that there are certain glitches in the application software, so you need your developer to be on hand to be able to amend and cure those defects. And in terms of royalties, the deals obviously vary in accordance to how much money you've got and to who the developer is, but normally it's a net receipts share, and it can be as much as 50% of net receipts That's after Apple take off its distribution commission, which is 30% on the iTunes application. Once you've got the development in stage, you then have to be aware of how the distributor, essentially Apple, manage the application process. And there are certain kind of pitfalls here that you have to be aware of, some of which relate to the use of music. You have to clear all the music in your app. That's on a full buyout basis, including any and all mechanicals. You have to have the ability to be able to know that you have bought out all the available content, and you've got the clearance for the celebrities that may be included within your app. So name and likeness issues and publicity, privacy issues, all have to be considered within the context of your application. The actual material of the application is also governed by Apple and also Google. Apple can object to what it considers to be objectionable material. There's no actual guidelines as to what this could be, but essentially at the moment the provisions prevent any obscene, pornographic, offensive or defamatory content. Google's is even more restrictive in that it prohibits nudity. But however, Google, as opposed to Apple, has an open process and allows developers to essentially publish whatever app they desire in the Android market, and it's up to the community to police any violations of the code. Obviously, you have to be aware of all the privacy issues and the personal information that you manage to garner, and have strong understanding of data protection laws. And once you've actually made your app, then you have the agreement with the end user. Apple has a standard form of end user agreement and allows you, the developer, to actually have an interface with your customers. But when you do that license, there are certain provisions within the Apple end user license which you have to include. So there are lots of legal implications to consider before embarking on an app development, but if you get it right, it could be a very lucrative exercise. Thank you.
Thank you, Jonathan. My name is Massimo Travostino. I'm a lawyer, and we assist clients in licensing contracts and digital distribution contracts. And I just wanted to point out a couple of issues concerning the value and the economics of such contracts. As we could hear from our colleagues, these kind of contracts are pretty different also between them. We can talk about multi-platform contracts concerning the distribution of a single work, which is distributed through different platforms. We can talk about the development of products, different products, to be distributed on different platforms based on one idea, for example, from one format. And we talk about multi-platform contracts. So we're not going to talk only about licensing, but also about development, some new applications, developing software, clearance of image rights, name rights, and so on. In any case, the common denominator of this contract is that in a lawyer's perspective, multi-platform means multiple rights contract. We are trying to maximize the revenue. The right owner wants to maximize the revenues from his product, and is trying to slice even more and more the pie is got. Everybody hopes that the pie doubles, slicing it so much, but the result is that such multiple and different rights become very, very difficult to distinguish between them. Then, as Louise clearly pointed out, the importance of definition of such rights. The markets, the borders between the markets become fuzzier. And so it is very important for the parties, for both parties, to clearly define what's the object of the contract, which kind of rights are licensed, are being negotiated. For the rights owner, it's very important to understand what kind of rights is giving out and what kind of rights can still negotiate in the future with third parties. One clauses that the licensee wants to negotiate, especially for premium contracts which have very high value, is the holdback period, duration period, which is a sort of negative exclusive, which obliges the licensor to abstain, to refrain from exploiting the same content on different platforms for a specified period of time, which could be 12 months or even more. Sometimes there is a first period which is included in the licensing fee, and then there could be some optional period which are paid additional licensing fees if the licensee wants to extend the holdback period. So the licensing of a product, of a content, to be broadcasted by pay-per-view television, for example, can be under an holdback period of 12 or 18 months, which obliges the licensor not to give and not to license the same content for other platforms. And this is a clause which is very often negotiated, as I told you, for premium contents, and which is usually under the free agreement of the parties, even if from certain countries, and I talk especially about Italy in this context, the regulatory authority are deeming that such clauses can be against the general interest and against the competitive rules. So there is also, a few weeks ago, the Authority of Communication in Italy issued a document that they are studying about a system of extended collective licenses concerning premium contents in order to limit the importance and the application of such holdback clauses that in case they are left just to negotiation to the parties may hamper and limit the distribution of content to the market, creating dominant positions. A second clause which goes more directly to the economics of a contract, and which is often negotiated in multi-platform contracts, is the cross-collateralization clause, which is usually excluded in standard terms and conditions of the licensor, but the licensee wants to usually negotiate. What does it mean? What is cross-collateralization? Usually these contracts provide for a minimum fee to be granted to licensor concerning a title or a category of contents, or also applied to a particular right, particular way of distribution of the content. The licensee wants to make that this minimum guaranteed may be compensated between different films or different categories of films for which it is applicable. So in case the revenues for a film are higher than the minimum guaranteed, such revenues, the exceeding amount of such revenues could cover the minimum fee which is provided for another title which does not reach the minimum fee as agreed in the contract. This is cross-collateralization. This is usually excluded in standard terms and conditions of the licensor, but it is very important to try to negotiate it, and obviously depending on the weight of the party and on the weight of the revenues that you can prospect to your counterpart, it is always very important to try to avoid the lack of cross-collateralization in the standard term and condition of the contract. Tom.
Thanks. I got one. I'm going to stand up. Did my slides work? Hello? So I have a standard disclaimer that I use whenever I use PowerPoint, because I abhor PowerPoint. I don't know how to use it. I think a lot of times people take a 500 or 600 word text and they put it on a PowerPoint and they call it a presentation. So, but this afternoon I was thinking about, I've been charged in my 5 minutes to talk about the exclusivity clause in a contract, and I think that it is the most important clause in a contract, but it's also, you know, the holdbacks are probably the most important clause in the contract, and I think that the reservation of rights is probably the most important clause in the contract, and I think the license term. So I did go to law school, so I'm inclined to think that way. But I want to talk about exclusivity and use it as a way to get into some of the more business affairs types of decision making that goes on when a decision is made to do a cross-platform license, or how you'll go about that. And so before I do this, somebody, I think it was in one of our sessions yesterday, talked about The Princess Bride. And I've been thinking about The Princess Bride lately because there have been a number of articles in the legal press in the States that say, you know, exclusivity, is it dead? And if you remember in The Princess Bride, they bring the main character to see Miracle Max because they think he's dead, and he says they're not dead. He's not dead, he's just mostly dead. And I think that's probably where we are with exclusivity right now. It's not dead, but it's certainly on life support. I don't think it's ever going to go away, but I want to talk a little bit about how the different inputs go into the decision about whether you grant an exclusive license or not in a multi-platform sort of area. So I've put together this chart. It's essentially meant to show the ecosystem around a particular property. I do want to say, when it was on my screen, that the words did fit inside the boxes. But the arrows, the color of the arrows, the length of the arrows, the scale of the arrows, the directions that they're going, it's not to scale. This is just meant to be a very basic illustration. And the color, some of them are green because I was really pleased that I could turn some of them blue, and I wanted to see if I could turn the other ones green. So, but if you think about the traditional relationship between the party that produces the content, the party that pays for that, usually the distributor, and then the party that pays the distributor, meaning the network, the advertiser, it was a fairly binary sort of decision. We're going to provide all the money for you, production company, to make whatever the content is. We're going to own all the rights. The advertiser is going to pay us some money. We're going to give them access to some eyeballs. And that's it. What I think we're going to see now, and I've been doing a lot of joint ventures around the multi-platform development of content, is a couple of things. We're going to see lots of different currency come into play that wasn't part of that original equation. We're going to see lots of claims to use and to ownership, and all of the people around a particular property will have a stake in that, or could. They could also play several roles. So, you know, production company, ancillary licensee, that's your merchandising, your audience, your viewers, or users if it's online, the advertiser. The distributor number one could be a network. Distributor number two could be your online distributor, could be Vivo, could be Hulu, could be anything, could be one for mobile, one for online. So there could be 5 or 6 times the number of boxes depending on the property. But when I say currency, oops, you think about it. These are all possibly exchanged in contracts around putting together a multi-platform deal. The IP rights, meaning if you're a brand owner, you own the IP rights. Exclusivity, if you grant someone rights, do they get the exclusive right to do it, or do others have the same right? The actual content that's produced, I think you can think about that as currency now going into that overall ecosystem. Money is obviously currency. Data is currency. Promotion, meaning the promise to promote whatever the property is. And then ownership's a currency, right? You can trade ownership in exchange for any of these. So, and I'm getting to exclusivity, I promise. So it's all a balance, and I would say that each of these relationships is a balance, because that's what you're trying to do in a contract. You're trying to exchange equal value. I'm going to give you IP in exchange for money. That's the same value as my IP, et cetera. But, so this is the old-fashioned way of doing it. I'll pay enough money, the IP owner will give you exclusivity and ownership of whatever it is you create, or both. Even when you talk about viewers, right? In the current ecosystem, I'm going to jump, a viewer could give you data, and then you give them the content for free in some cases. Or maybe they'd give you money because they wanted to control more access. And if they gave you money, then maybe you give them ownership, and maybe you do a download to own instead of a streaming sort of deal. But if you think about it, all of these on both sides get exchanged. And so you could put a check mark next to each of these and a check mark next to each of these, make a deal. But this is how it still looks to most people, right? Someone, and I think this is a mix of people who are new to the multi-platform environment as well. This is how they came into it. We have money, give us exclusivity. We don't care so much about that. And so what I'd like, I just want to leave you, I'm getting to the end of my 5 minutes, is with the idea that exclusivity can be something that is traded for anything on the other side in a contract, in a new negotiation. But it better come with a pretty high price, because there are lots of different ways to use your IP rights. There's lots of content. Maybe if, another example, if an advertiser is going to put money into it, into whatever the property is, and they're going to get data, they're giving you two kinds of currency. So you better give them exclusivity, or it's much more likely they'll argue for exclusivity than if they're only putting money in, or they're only putting data in. Or if you're giving them data, then they better pay you more, and maybe you don't give them exclusivity. So it's a balance, but I think as you start thinking about each of those, and I think you'll see each of these elements in every multi-platform contract in one way or another. Don't give up don't give exclusivity unless you're getting significant other elements in the deal.
So, hello? So let's discuss what rights are licensed and on what platforms. We've had a lot of discussion about grant of rights, exclusivity, holdbacks, windows, cross-collateralization. All of these concepts relate, and they all operate based on what the definitions in the contracts are. The licensee naturally is going to ask for all rights in all media now known and hereinafter developed. The licensor tends to want to limit the grant of rights just to what platforms were intended. But how do we define them? What's the difference between a mobile phone and a laptop and an iPad? Laptops are more like PCs than phones, but what's the distinguishing factor? Is it the screen size? Is it the wireless connectivity? How do you define these things, and how do you write definitions now that will apply in a beneficial way to contracts that are going to have effect in the future? So I'm really, really curious about your opinions on this.
I'll start. We try to assess whether or not defining the rights that are granted along, based on the device that they're going to be used on. We try to assess whether that's really relevant any longer in a particular agreement, and we spend more time talking about what it is that is actually being licensed on almost an assumption that it can be accessed in multiple platforms. So unless there's something very specific, the application is really intended for a specific device, like an app for a particular phone type, we spend a lot of time saying, not as relevant as what is this? I mean, it's come up recently in e-books. What's a book? I mean, most people can define a book. It's something made of paper with words printed on it. What is an e-book? There's content in there. Content changes based on what the users do. Is it still a book? Who's getting a royalty? Who's paying them? Who's acquiring the data? That sort of thing. So there's a lot more pressure on that part of the deal than the device definition, I think.
I could point out a couple of of critical issues that we always deal with while assisting clients. First one is trying to map and audit internally and prepare before licensing, giving out contents, the range of rights that they are going and they intend to license, not only to the counterpart in that particular deal, but in the future. And this comes the second problematic issue, which is critical. Technology is changing, markets are changing from month to month, and figures are changing of such markets. The appreciation of a deal is changing, so the duration of the contract is another critical issue. Such contracts are still based on a 2, 3, 4 years period, maybe 2 years with an option. We're talking about maybe majors with an option to the licensor for other 2 years, while we have a market that we do not know what will happen in 6 months. So this is another critical issue that have to be very well negotiated and taken into account while before signing a contract.
Can you use a clause that says we're licensing you for this platform and any other platforms developed in the future? Like we do that in the U.S.
If we are talking about Italian law does not allow you to license future rights. So it's not applicable under Italian law. And other civil law countries, differently from common law.
Until recently, that was also true under German law. And German law has since adopted a very complicated procedure for equitable remuneration for licensing of rights in these future media that has proven very difficult and a source of major litigation in that territory. In general, on definitions, again, I want to say this is one of the most difficult issues in how you make it viable for the future. I recently spent the past, gosh, I can't even remember how long it is. It was supposed to be 1 year, and it turned into 2 or 3 years with the Independent Film and Television Alliance Legal Committee revising their model licensing agreements. About in 2005, IFTA made the decision that although we didn't know exactly what these media would look like, it was better to find a method to allow people to license it than to continue to have people freeze and hold it and have the risk of piracy taking over. So they made a decision that was first to license so-called internet rights and subsequently wireless rights. Those were tied to devices. Probably, history has proven that that was no longer a viable distinction. And in the most recent definitions, I don't know, has anyone here actually tried to use the IFTA definitions? We wrestled with this a lot. The distinction that the committee came up with was between essentially open internet exploitation. That is it streaming via a public internet or downloading via public internet, or is it through some kind of closed net, which would include mobile services that you can only access through a particular mobile telephone provider. It would include internet services that come in through a set-top box, something that I think of as IPTV, but that definition is far from standard or universal. And we tried to make that distinction, I think, historically, I think we'll have to see whether or not that works. And in the moment, it's proving a bit unwieldy because people are saying, well, what's mobile? What's an iPad? What's this? What's that? So it's requiring a lot of explanation and a lot of thought. But again, I think the choice has got to be to figure out a way to make things work and to be able to license them now, because that's what the public is demanding. And the movie business and television business, they had a good 10 years of instruction from the music business about what happens if you don't make these things available. And I think they've sort of dropped the ball, so.
Yeah, I was also going to say that the business model has changed exponentially. I mean, if you look at in terms of film distribution on a territorial by territory basis, I mean, you can't exploit internet aggregated content on a territory by territory basis. So, with a sales agent, and if you're an independent producer and you're negotiating with a sales agent, and from the individual producer's perspective, you want to reserve those rights, the sales agent will resist it. But in terms of being able to exploit it, it can't exploit it through an individual distributor unless that distributor takes a multiple of rights. So it's an interesting negotiating position at the moment.
I want to spice things up a little bit and agree aggressively with you. It really is about the consumer. I was in the music business for a long time. I used to come here for Meetum. And I heard a lot of chat about, well, we haven't cleared these rights, and We want to make sure we're creating a universal DRM, which is now very similar to what Ultraviolet's talking about. And we're going to have this control, we're going to have this control, we're going to have this control. At the end of the day, it didn't matter. What mattered was, it was what the market demanded and the consumers demanded that changed that industry. So that industry now has absolutely zero control over their product once it's produced. It goes out into ether, and it goes wherever it is. Another example is my 75-year-old mom. She's not exactly the high school kid in the dorm room, or college kid in the dorm room. But she's like, well, I bought this movie. Why can't I put it on my iPod? I'm going to take the train down to Florida, because that's what elderly people do in America, and I want to watch my movie on the train on my iPod. She went out and figured out how to do it, even though it clearly says on the back that it is copyright protected and, you know, this is only a license to this product. It really didn't matter. It's what the consumers want, and the consumers will figure it out. It also goes into deeper areas like windowing. You know, Battlestar Galactica was a great example. Huge cult following. It aired on Sky in the UK before it aired in the United States. People were already watching it in the United States. And we're going to see more and more of those types of things, whether it's professional sports being streamed out of China or whatever the case might be because the local team decided to black out the game. You know, it's a consumer revolt against all these control windows that to most people are artificial to them.
But one of the other forces we're seeing at play here is people will, if there is no way that they can pay to get the content, then they will go around the protections. There is a point at which it is cheaper for them to pay than it is for them to try to hack whatever protection you've put in. And so think about the Radiohead, you know, Pay What You Want for their 2 albums ago. Was Gavin here? Do you know what Radiohead was paid on average for the album it made available that you could pay whatever you wanted as long as it was at least 1 cent? No, it was more than $3. It was $7. So there was a point at which it was cheaper to pay $7, and people thought they were getting enough value, as opposed to going on BitTorrent and downloading it for free.
There's also ease of use.
Yeah.
That's a big factor. My mother is not, she couldn't not afford to buy it on iTunes. She just thought it was unfathomable that she had to repurchase the content.
So traditionally, reserving rights was always a very key thing for a licensor. That way you could protect the rights, you could window them and maximize the economic benefit of owning the property. But now, in light of the forces Peter's talking about and the changing definitions, how do you structure windowing in a fast-moving environment? How do you try to do what is possible and realistic in the current environment?
Let me comment on that, because I think the United States is, in many respects, has been and still is the source of windows and the source of the windowing development. Basically, the industry figured out in the past that the best way to make money off of a property was to slice and dice it into many different pieces and sell them off individually. And in the digital world, this is just simply non-functional. Yet, the expression I heard in a panel earlier today from a venture capitalist is that the traditional media company are spending all of their time trying to preserve yesterday's profits instead of looking at future profits. So the response of the studios and the big content providers in the United States is to try and come up with a realignment of the windows or smaller windows or creating new windows. And I just want to give 2 examples of that. The first would be a window that would be, a system that would allow day and date release with theatrical on a VOD system. It's the investors in that are Best Buy and Universal Pictures. This was started at the time, I should note, when Universal Pictures was owned by General Electric. It is now owned by Comcast, and so their interest in this may change dramatically. The idea is that if you pay a one-time fee of $20,000 for a digital delivery system and an additional $500 per film, you can get it in your home day and date with theatrical release. They clearly acknowledge that they're not marketing to a broad consumer audience. They're marketing to people who have home theaters. And unfortunately, I have to say, one of my nephews is working in this company and has a big stake in its success. And I'm concerned for him. However, I would also point out his job is to create the security and anti-piracy software for the system. And I think if he's able to come up with something that is at all good, yes, it will be hacked, but more likely this will be the primary asset of the company and they may be able to sell it to other people. The most recent windowing decision that you've probably all heard about is, well, first of all, my cable company advertises that I can see a movie on pay-per-view. This is just cable pay-per-view, 28 whole days before Netflix, which is obviously DVD and internet streaming. And I wonder what they're thinking when they do this. Who is going to want to see a movie so much that that 28 days is going to make a difference? I think consumers are going to commit to either a subscription service or to pay as they go, and then they're going to want to see it when they want to see it. There is, let's see, DirecTV is now offering, at least in theory, new releases through their video on demand service within 60 days of theatrical debut and a month ahead of DVD release. Rental cost to consumers, $30. I'm not sure who's going to be willing to pay $30 to get something 30 days sooner.
One of the things that we've seen a number of times is subscription-based services like cable premium channels like HBO and Starz. When they go to a free VOD model, meaning any movie that they have on their schedule, you can also see that month at any time for free, or it's no charge as an add-on, their churn goes down in number of subscribers, then their revenue goes up. And it's counterintuitive, but it has allowed many of the premium cable operators or cable networks to increase their revenue. So it's not really, they're not giving something away, and they're not losing money on this by any means. They are certainly increasing their revenue, even though what they're giving to the consumers costs nothing to the consumer.
Well, I think
it goes against everything that all these guys are fighting about right now.
I think it also depends on how much promotional dollars a service is putting behind a particular film or a particular service.
And it's also ease of use.
Yeah.
Pay-per-view has been around for a long time, and it hasn't exactly been very successful.
When you
I'm sorry. No, I just want to say we in Italy in particular, we had a legal Windows system until 13 years ago, 98. Then it's free for rights holders to establish the Windows. And the Windows that currently we have are more or less the same than in Europe: theatrical, home video, pay TV, and then free TV, VOD. But now what we are assisting in is that VOD services are demanding for closer windows. Video is declining, is dramatically declining, and it's about to disappear soon, probably. And VOD, sorry. A VOD, they want to replace it, so they want to get closer to the same window as home video has got now.
So I can say that for a lot of Chinese films, the home video market has almost disappeared. It now almost skips straight to pay-per-view, and because they're earning money from it.
And when you talk about windowing, usually you're thinking about protecting different platforms and protecting the economic potential of each platform. You also have an issue with geographic timing of the release of the content. As John had mentioned, there are cultural issues. You have issues with advertisers, that they have different rights, different advertising exclusivity in different markets. How do you negotiate that? How do you protect against, protect that? John, do you deal with this in your market?
Well, as I alluded to, it happens most often with feeds that come in from other jurisdictions, and I've had situations where in some territories the responsibility has been passed, or it's given to the licensor, which I think is almost impossible for them to manage, because the regulatory environment changes relatively briskly in some of these jurisdictions. But then are they prepared to allow the licensee to essentially manage that process for them? And certainly in one territory, the dominant pay broadcaster negotiates a 2-minute delay window and literally sits there and edits real time to address any issues that arise. I think that's an extreme example, but it's either that or the licensor is going to be repurposing I don't know how many fees to address 7, 8 very different markets.
I've had a lot of experience representing a buyer for the former Soviet Union, CIS, Russia. And one of the things that we discovered after diligent research, we were getting contracts that were putting a video window 6 to 12 months from theatrical release, and free TV windows 12 to 24 months from theatrical release. And what we discovered just by looking at release dates in the territory, the studios are releasing films on video 4 to 6 weeks after theatrical release, because this is a high piracy territory. And if you don't get the videos out soon, that market absolutely disappears. Also, there's a relatively low concentration of cable and satellite TV within a large part of the territory. So there may be no difference between the time in which something's released to pay TV and free TV. And the free TV stations were paying the most money, so naturally they got precedence, contrary to everyone's popular beliefs. And it used to drive the licensors nuts, because they've got American deals for release, and the US companies are trying to get worldwide holdbacks against their own free TV releases, which are just unrealistically long anywhere else in the world at this point.
Something I wanted to mention earlier, but in this sort of new model we're talking about, where you have different platforms that you can exploit content on and different windows, it's no longer possible to ignore the fact that there is promotional value provided to other windows if you have a strong release in the first window. Take that to another level. If you are doing a deal for television and the production company keeps the license rights, or the rights to do ancillary merchandising, I think gone are the days when automatically the owner of the IP will keep all of the revenue, because there is some promotional value to having a show be very popular and being well produced and well promoted. So while there's more ability to keep the rights back from the networks than there were, because they are putting less money into the pie, it's also gone are the days of sort of binary decision making, meaning you're the broadcaster, you don't get a piece of any of the other ways that we exploit it. And so I think our experience with multi-platform will start to feed back into the sort of decision-making loop, and we'll actually start seeing real, value being given back to the different windows holders, because their contribution to the overall pot is actually increasing.
And that bears on exclusivity, doesn't it? Because the network says, why are we promoting and developing all this value that's being realized on other platforms where we don't have the rights? So they'll want to participate more and more as they're creating the value that drives the product.
Yeah, it was a couple of years ago that if there was a deficit in the financing because the network wasn't going to put up all the money, there was this battle, you know, it doesn't matter, I'm the network, I get the rights, or, you know, I get some of the rights. No, we keep them, but nobody knew what to do with them. Or it was hard to articulate the value. Now, I think people have gotten very good at articulating. We're better at articulating the value. If you're doing a music show and you're allowed as the producer to keep the publishing rights, so you should be able to make an argument that you will find a partner who is better than the network at exploiting the publishing rights. And you're willing to sweeten the pot a little bit by giving the network those, you know, a percentage of that. So that's one example of that sort of articulation of the business model.
You know, as you go around MIP TV and connected creativity, everybody seems to be talking about opportunities of multi-platform licensing. And as you can see, there is so much, you know, detail and so much knowledge that's necessary to effectively negotiate the deals. And I think we could just keep talking for a while about this. But time is short, and we wanted to leave some time for questions. Do we have questions from the audience at this stage? I guess we do. Yes, you, sir.
Don't you think actually eventually, because the value is decreasing in all content and because of the ubiquitous distribution through the internet, that actually the legal industry itself is going to become redundant?
Absolutely not.
No, you would say that, but I mean, what's, you know, I'm saying to John earlier, I met this company from Holland called Linkbusters who monitor the BitTorrent sites. And the amount of illegal downloading is just phenomenal. I mean, Random House employ this company to monitor the book from Bill Clinton, Tony Blair, and George Bush. And it's hundreds of thousands of illegal copies every week. And it's the same in music, even far more so. So what's the point of actually trying to protect something when there's going to be just such rampant downloading?
Well, you know, it's interesting because attorneys need clients to represent, and we need strong, economically viable clients. But on the other hand, I think for me, and I think for the other panelists, this is the most fascinating time to be an attorney in this space. The issues are more complex. We're drawing on all our experience from the past, but the challenges just keep coming and become more and more interesting. So it seems to be a time when it's more fascinating than ever to be on the deal-making side. But I'd be interested in my panelists' opinions.
I don't think the industry's going to disappear. I don't think the industry's going to disappear. There's still, an inordinate value in the theatrical release. And obviously in the United Kingdom, we're very privileged to have the BBC. So it will pay a significant premium for any content just to be able to broadcast it on the BBC channels. The major shift is DVD. And that's a big gap in the business model until it gets replaced eventually through pay-per-view or video on demand, where broadband access and affordability and accessibility will allow the end user to be able to purchase the content for affordable prices.
Even in documentaries, for example, I mean, the budgets for documentaries, even with the BBC, who are a very renowned producer, are just going less and less and less and less. And even people like Storyville, who have an international reputation, they just don't have the budgets anymore because the money's not coming back into the system.
Well, I think you'll see, what we're starting to realize is that there's a correlation between piracy in a particular territory and success on the paid side in a territory. So there are smart companies that are looking at the BitTorrent download rates as a predictive measure and selling, and they're able to drive higher prices for the content on the paid, on the legit side of the house, based on what they're seeing in sort of the pirating trends. But I also think, you know, content that's good will be paid for as long as it's the right price and the ease of access is right, and it will be better. Most consumers would rather pay for it, I think, if it's easy to do and it's the right price.
I think one of the phenomenon you're talking about that I'm really seeing as a long-term trend is television becoming more and more like radio. And having to figure out, I mean, it's unclear to me whether the ad-supported model that works in radio will work for audiovisual materials. But I think everyone is having to find new streams of revenues and finding new ways to share existing revenues. The classic example being, you know, historically in the music business, live concert revenues were the sole property of the artists. Well, that isn't true anymore. The record labels who lost out in the digital wars are now insisting on sharing those where they can, you know, with artists who just don't have clout. So I think the role of lawyers will change in all of this. You know, I think the role of lawyers in helping parties work through the allocations of risk and the sharing of revenues is a function that hopefully will continue. But I really think lawyers, and myself included, were responsible for slowing down the music industry in adopting these changes. And we kept saying, what about the collecting societies? What about the publishers? What about this? And in hindsight, it was a mistake.
Hi, my name's Patrick Tao from a company called Gland Media Ventures in the UK. We're running a European funded pilot to look at different kind of monetization models. And I was going to ask you just about this kind of idea of the pot. So there's different contributions to something being successful, and there's different revenues. But for instance, the models that we're looking at are non-traditional venues where it may be not a cinema, maybe just like a pub or a club or a hall or something like that. And then they may choose to not take a ticket price. What they'll do is have enhanced revenues because there is a piece of audiovisual playing. What we've got to do is to come up with some kind of first transparency about the revenues so that rights holders believes that we and the venues are not ripping them off. And secondly, come up with some kind of equitable share of that pot, so that it isn't just a question that the film is shown, oh dear, we didn't have any ticket sales, but we sold a lot of beer. So I just wondered whether you had any thoughts on that in terms of, I suppose, how to evidence what a fair split should be. It's germane, because in the next 6 months I need to design the way we do evidence that.
I'd go back to the idea that not all currency is money, and at some point, you know, advertisers particularly will pay dearly for the ability to get the right advertising message in front of the right person, even if it has nothing to do with that person's interaction. You know, what do I mean? If you're learning about a user of a piece of audiovisual content, that is relevant and something that the advertiser will pay dearly for, even if they have nothing to do with that piece of content itself. It's a new market. It's a new piece of currency.
This suggests that maybe the studios will soon be asking the movie theaters to share the concession revenues. And I mean, when you say it, it's like all of a sudden this is not a strange and far out proposition. The one example that comes to mind in this context, and again, I'm making parallels to sort of old world media, but when someone buys or licenses a property that has pre-existing merchandise, very often what you will look at is what is the value, what sort of revenue was that merchandising bringing in the past, and then you're sharing the bump that the uplift that the premium, the freemium gives you. So, you know, looking at annual revenues or weekly revenues or daily revenues from a pub over a particular time, and then seeing how they spike when a particular program is added. That's one possibility that occurs.
Can I just ask a tiny follow-up? So I think we're at the strap line above your head says content, and I think there's a fundamental problem. We ran an event with Grant Thornton with 9 trade bodies in the UK, and we got them to all agree that in effect it was the experience that users valued, and so it was that they were paying for, and the experience is much more of a doing thing than a noun. So all of the licenses that I've seen and negotiated very much focus on the nouns, the stuff, Whereas in fact, if you look at, say, if I take a picture of a copyrighted image and MMS it to someone, I'm paying nothing for the thing. What I'm paying for is the sharing it with someone. So do you think that there's a shift also to kind of modelling better the verbs within the contracts and having less emphasis on the nouns? It's a kind of philosophical point about how you construct these agreements.
I'm not so sure that that's entirely true, because remember, in the entertainment industry, you're dealing with something where the thing is an intangible. It's a copyright. I think the Japanese word for motion picture is something like flickering light, or I mean, it's a term that doesn't describe a thing. I think we are certainly moving away from an industry where the DVD as hard goods were an incredibly valuable thing. My real question is, I don't know how to monetize all the aspects of the experience. We know how to monetize the experience of sitting in a movie theater. We know more or less how to monetize, at least through ad-supported television, the experience of watching television. We're beginning to figure out how to monetize certain kinds of sharing arrangements through social networking games that Zynga is very good at. But there has to be some way to create value for everyone in the chain. Admittedly, it doesn't all have to be monetary, but a lot of it has to be monetary.
Well, but I said but I agree with you. But you've got a system based on ticking the box every time, and one of the things that we've seen clients starting to shift on is moving away from the idea that every time a piece of content is viewed by a human being, that money is exchanged between two parties. And I thought maybe where you were going was, I think it's filmclips.com is the website where you can see clips that have been provided by the movie studios to this website. And as I do no work for them, I understand that it's a fairly cheap, if not free license that is granted to Film Clips, which does a very good job of mining the data as to who watches not just the clip that they've selected, but also other clips that they go look at because they're tagged and cross-indexed and other science kind of words. So if the movie studio is able to run 3 versions of a trailer for 4 weeks and closer to release date, and realizes that one of them is playing better in the eastern part of the country and one's playing better on the western part of the country, or better for men, better for women, then the trailer that was used will be more effective, and you'll get lift over where you would have if you just gone blindly and just put one trailer out there.
Yeah, I mean, just as we ran an event, we ran a project funded by the UK government on the future of data-driven innovation for the creative industries, and I think that kind of insight data and the ownership and control of it, and actually one of the issues is the ability to knit together different bits of insight data from different people in the value chain, and how much more valuable it can be. That's just not at all represented in the contracts and agreements at the moment.
And one of the things we found, and if you switch over to the privacy side of this equation for a second, we have 2 or 3 partners who are really pushing the idea of data arbitrage, where most big companies want their lawyers to say you absolutely cannot do, and give them a list of 50 things that they might like to do, but they can't. And so there is a market there to take all of the different laws and all the different agreements that you've entered into and find the place where you can actually get lift or arbitrage the data. But it's not being done very much.
Did we have other questions? Yes.
Hello, excellent panel. Thank you. If we could get this quality of advice given so quickly by council, my legal bills would be so much lower. So thank you very much. I'm the CEO of Fremantle Media Enterprises in North and South America. We do about 10,000 hours of TV, thousands of license deals a year across all of the areas you've discussed today, from TV to digital to merchandising, live events, cruise ships, everything. before you guys get to come and help us and craft a deal that touches all of these areas of whether it's start with the platform or the monetization or the type of content, people like me get to be in a room and negotiate some elements of it. Where do we screw up? What really pisses you off about the client, the brand owners like me? How do we go wrong that leads us to not get the best out of your expertise?
I mean, in my view, and this is something that no client wants to hear, I think a lot of clients do not bring in their legal counsel early enough into a transaction. Because certainly in North America, this may not be true in all parts of Europe. I think it's probably true in the UK and some other places. But your lawyer can do both business and legal affairs. And your lawyer can help you interface and figure out what your strategies should be in negotiations. Now, as I said, you don't want to hear that because it means you have to start paying us sooner. But sometimes there's an advantage to consulting with your lawyer before you devise your strategy and go into that room.
I think that I totally agree with that, and I'm a big fan of wartime conciliary, I think was the phrase. But there are 1,000 conversations you have before you get to 10 that might become a deal. So you do have to be quite selective about when you can do that, I think.
Yes, I agree.
Yeah, I actually disagree. I think that people will say things and negotiate things much easier in a freer atmosphere. And I just went through this with a very large media company. If I was to bring my attorney with me to a conversation, they would be obliged to do the same thing. And so that process doesn't allow for an open dialogue and creativity around getting the deal done. In fact, I wound up calling him back after our official phone call to actually get the deal done, one-on-one.
You don't have the right lawyer.
But I think actually what Louise is suggesting is that actually before you go into a room with a client, actually sitting down and saying, okay, this is what we want to do. What do you think? How should we be structuring this? I mean, I don't think, and I agree with you, it's not always appropriate to drag your lawyer to every meeting. It can be a bit intimidating, but I think in terms of setting a strategy, absolutely.
I think
John has that right.
I think the question really reveals a lot about the difference between different executives. You're asking that question, which shows a lot about you, but other executives, they don't think that way sometimes. They don't consult with their own counsel before they go, and then they have the big dinner and they have a discussion and they have a price and a term, and maybe that's all they have. And then they go to their lawyer and they say, do the deal. And the lawyer says, well, how about this, how about that? What are the windows? What's the territory? And maybe that wasn't thought through or discussed. And not that all the details have to be addressed necessarily when the two opposing executives meet and come up with the germ of the deal. But if you have an idea about the scope of things, if you've been informed by a discussion with your counsel, it can really accelerate things and protect your company much better than if you don't.
Yeah, I think it's important for production companies to be aware of the rights that they have and what they can and cannot do. For example, we have for a production company that is a licensee of a format owned by a US network. Now, as a consequence of that format, there are a number of ancillary rights. It relates to, it's called Britain's Next Top Model. And so, I mean, as a consequence of the program, it is discovering new talent. And that talent is not represented. So there's obviously opportunities for that production company to get involved. There's also ancillary markets and seminars and organizations, conferences relating to merchandising, which is ancillary to that product. And so there is ability for the production company to get involved. So it's really kind of understanding and appreciation of the different ancillary markets available right now.
I think that, first of all, you have to make sure your lawyer is very well dressed at all times. The other thing is, we've gone through an exercise with a number of clients recently who have said we don't have either we don't have the will or the cash to spend to have you in every meeting, but we've put together almost sort of a slider, if you will. Imagine for every common issue that's described, a mechanism whereby you define the outer perimeters that you're willing to do in any deal, and then talk about what you are willing to give up in order to get more favorable terms on another one of those issues. So if you slide exclusivity all the way to non-exclusivity, then the money had better go. But you might be willing to give more rights away for more money or less money. And so that's another way that you can just get your execs in the room, get them to understand how that the issues are integrated, then go out and then come back to us and have a deal that we don't have to unwind or redo or bring up new issues.
Well, as new platforms and devices are emerging, business models are changing with them. And as a result, attorneys negotiating these deals need to be more than just good lawyers. They have to be up on the latest technological and business developments. They need to understand and anticipate how the changing environment is creating opportunities and risks for their clients. The International Association of Entertainment Lawyers is very proud to have been able to present this panel discussion for you today. I hope you found it to be engaging and informative. I'd like to thank Reed Meadam for all of their support, and especially thank our panelists. Thank you all very much.